All right. Okay. So Chris Berry with Castle Wealth Group. We do these and I'm a certified financial planner, certified LL attorney, and we do these webinars generally about once a week, answering legal, financial, and tax plan questions people have. So, and I always like to start with positive focus, something positive that happened over last week. And for me, I guess two. One, the Pistons won. So that means we have game 6 coming to Detroit tomorrow. That's kind of fun. And then my daughter, she won her soccer game at the high school, 9-0, and she scored a goal, left-footed goal too. So that was pretty cool. And I coach her in soccer, so that's always fun. All right, so I have a couple questions coming in, and one thing I want to talk about, and this just kind of happened actually earlier today. So I was meeting with some clients, and we're talking about how to handle real estate, and we're talking about liability. So a lot of people have a primary residence. In this situation, they had a couple of rental properties. So the question is, how do we protect ourselves from liability when we own like rental properties? And what I expressed to the clients is there's two ways that liability can go. So one is if you cause liability. So I kind of facetiously say if you do something stupid, like if you get in a car accident and you injure someone, that's liability caused by you. Or something that they brought up in the meeting, they have two children who are about to be drivers, and if they were in a car accident, maybe now as parents, they might get sued. So that's one form of liability. Kind of continuing on that thought, is also like liability because of long-term care costs, like nursing home or Medicaid spend down. So the way that we protect against that type of liability is by setting up an asset protection trust. We call it a castle trust. We move the assets into the trust. Now we're protected from any potential personal liability. Likewise, I sat down with individual, they had a partner, but they weren't married. So if we move the assets into the asset protection trust, the castle trust, whatever's inside of the trust would be protected from any future divorces. So it's protecting against individual liability with that asset protection trust. Keep in mind, a revocable living trust doesn't have any personal liability protection. So that's one form of liability, is protecting against something caused by you. But in this situation, and a lot of my clients, they have rental properties, and we call those a hot asset, where now you might have a slip and fall, and because of this hot asset, they could come after everything else that you own. And even if we put that hot asset into the asset protection trust, they can take whatever's inside of the trust. So that's where a lot of times when we have second pieces of property, things other than a primary residence, we might set up like a limited liability company. So if we think of that house, that rental is like a hot asset, we put a box around that hot asset. So now they can only take what is inside of the box. Or if we have multiple properties, a lot of times we'll do a series of LLCs, LLC, limited liability, limiting the liability, limited liability company for each one of those properties. So now if something happens to one, all they can take is what's inside of that one LLC. They can't take whatever else is in there. So just understand there's like two forms of liability, because if we don't have those LLCs or I'm sorry, if we don't have the asset protection trust, and let's say that LLC is in your name, and then you get in a car accident, you get sued, you go through a divorce, because the LLC is in your name, it's no different than owning like stock or any other type of investment. They can take it. But by setting up the asset protection trust, that protects against your liability that you may cause. And then by having the LLCs for those hot assets, like the rental properties, you're protecting against any liability caused by those properties. And so it's just creating the legal structures to achieve what our clients are trying to accomplish in terms of protecting against liability, avoiding probate, making sure stuff goes where it's supposed to go. So understand if you do have things like rental properties or second pieces of real estate, you might want to look at more than just a trust. You might want to look at ways to limit the liability. A lot of times it's limited liability company of those hot assets. So hopefully that was helpful. All right, now here's a couple of questions that just came in. Here, all right. What are the negatives to using Roth IRA money to buy an automobile. I would like to be free and clear of car payments. Okay. So, yeah. All right. So the question is, we have Roth IRA money and we want to pay for something like a car, and we don't want to have car payments. So first we need to understand like what a Roth IRA is. So a Roth IRA, it's money you've already paid tax on, and that money grows tax-free. And so, especially if you think taxes are going up in the future, typically that would be what we call later bucket money. That would be the last type of money that you want to use because you want this time horizon where it continues to grow tax-free. And that's great money to leave in terms of legacy to the next generation. Or for your retirement, that's the last money we want to use because that grows tax-free. So if we're looking at some expense, and everyone's situation is going to be a little different, but if we're looking at it from a tax perspective, I look at, there's kind of three buckets. You can have tax deferred money, which is money you're going to pay tax on whenever you use it. You're always going to have to pay tax. It's just a matter of when and how. We have non-qualified money, which is post-tax money, but you have to pay capital gains on any growth. And then we have tax-free money, money like a Roth IRA that grows completely tax-free. So especially if you think taxes are going up, the first money I would try to use paying attention to your tax brackets, but I would look at pulling money from a traditional IRA or 401k, pay the tax as long as it's not jumping you up into a next higher tax bracket. So that would probably be the first money that I would use. The second money would be post-tax money, non-qualified money like checking, savings. Really, the last money I'd want to use would be the Roth money, because that, or money inside of an asset protection trust, because that money goes to beneficiaries tax-free. If it's in a trust, it's asset protected. If it's in a Roth, it grows tax-free. So that'd be my recommendation, is the Roth money would be the last money I want to touch. All right. Here's another question. All right. So question is, recently closed out my father's estate. We have funds to invest. We're looking at things like multi-year guaranteed annuities, high yield savings accounts, things like that. Yeah, so let's say you get an inheritance. So the question is, what do you do with it? My first question would be, again, looking at time horizons, like when do we think we would use this money? So if it's money we think we might need over the next year, I consider that like now bucket money. So that should be safe liquid. That should be in cash, maybe a high yield savings account. Like right now we have a high yield savings account that offers 4%. You can move money in, you can move money out. So short term, like within a year, I would say like a high yield savings account. If it's kind of soon bucket money, money we might need over the next, say, 1 to 10 years, somewhere in there, then yeah, that's where we can look at things like multi-year guaranteed annuities that can guarantee a certain rate of return over a period of time. So like a 3-year multi-year guaranteed annuity might be offering a guaranteed rate of 5%. Which you're not getting rich off this, but especially if you think the feds are going to cut the rates, which a lot of people think they will, then maybe that makes sense. So it's principal protected. You're getting that guaranteed 5% rate of return, or maybe if it's longer, 6%. The downside of that is if you use the money before that, or if you try to take it out, you might pay a fee. So as long as you're comfortable with that, giving up that liquidity short term, that may make sense. And then if you look at this as money we're not using over, say, the next 10 years, later bucket money, then I might put that into the market. Just because if you zoom out, you look historically, like the market's going to get a better rate of return over time. Short term, we're going to have ups and downs, especially right now. But longer term, we're going to get a better rate of return. So I almost always look at like time horizons, like how quickly do we think we're going to need to use this money, or do we want to use that money? And then that'll give us the answer. If it's within a year, let's keep it safe, liquid, maybe a high yield savings account at 4%. If it's something that's going to be a longer time horizon, maybe we look at like a multi-year guaranteed annuity. It's giving you a fixed rate of return for a period of time, or maybe some conservative investments. And then if it's more longer term, say over 10 years, then I would say put the money in the market. just kind of generally speaking. Long-term 1 to 10 years, yeah. So just kind of look, and it could be some combination of that. It could be, hey, you know what, maybe we want half that, we want to use that within the next couple of years. That goes into a multi-year guaranteed annuity. Maybe the rest of it goes into the market. Okay. All right, here's a couple more questions that came in. All right. On both powers of attorney and executor for a trust, if listing two people is better to have and or next line read can work independently. Questions, do financial and medical places read it as intended, or do they have to work together? All right, so let me kind of break this up into kind of two questions and try to restate it. So the first question is, when you name someone as an agent, whether it's a power of attorney, whether it's a trustee, whether it's an executor, is it better to have multiple people together or successors? Really, there's three ways to do it. So one, we can have successors, and this is probably the most common way. So we have one person, if not that person, then the next person, if not that person, then the next person. So one person acts, if they pass away or unavailable, then it flows to the next person, and then likewise the next person. So the advantage of that is you don't have too many cooks in the kitchen, you know who's acting. The other way we can do it is we can have a joint where those people have to act together. So they have to sign off on everything. So if we're writing checks, they both have to sign the check. This could be a good check and balance, so everyone knows what's going on. The downside of it is logistically, it could be a pain in the butt because now whoever is named joint has to sign off on everything. The third option is we can have a joint with independent authority to act, where either person can act. Logistically, it makes it easier. So if one person wants to handle some stuff, the other person can handle other stuff. But you don't have that check and balance. And if they disagree, it could be a problem. So those are the three ways that we handle it. And really, it just depends on family dynamics. I would say typically we have it one person followed by another, followed by another. But there's quite often we have it like joint where they have to act together, or joint where either one can act. And we can have it different for the different roles. Like some people want their medical power of attorney, all three kids to sign off on making like end of life decisions. But like on the financial power of attorney, it's all right, maybe one of my kids is living with me and they're the ones to take care of things. So really just depends on the family dynamic. Questions is financial places read it. And then the second question is do like the financial institutions and medical institutions like follow these? The answer is yes. That said, whenever you're working with a bank or even like a medical institution, understand they're not lawyers, so it's going to be to a certain extent up to whoever you're talking to, and you could talk to someone else the next day, they'll give you a different answer. But that's where sometimes families will get us involved and we have to say, hey, no, this is what the document says, you got to follow the document. All right, another question here. When one person passes with a trust, do you have to post a notice to creditors for outstanding bills? Can you do it when the second person passes on the or second person in the trust passes of past few years ago? Should you do it now? Yep. So the question here is when someone passes away, and let's say you have a trust, meaning nothing ends up in probate, should you do a notice to creditors? So what a notice to creditors does is it says from the time you post that notice, there's a 5 or 4 month window where if there's any creditors that you don't know, they're barred from trying to come after anything. Now you still, if there are known creditors, you still have to pay off the known creditors as long as it's like a secured debt, unlike credit card debt. But what the notice of creditors is doing is from the time it's posted, it cuts off any future creditors from filing a claim. And the way you do it is a lot of times in Michigan, we just post it to the legal news, costs like maybe $100 or something like that. In my experience, like in 20 years of doing this, I've never had an issue where some unknown creditor came out of the woodworks to make a claim on anyone. I would say it's probably not necessary, but I'm sure that there's situations where it's happened. So if it makes you feel comfortable, gives you peace of mind, then spend $100, post the notice to creditors. But again, in my 20 years of doing this, not once have I seen like some random creditor come out of the woodworks where by posting that notice to creditors, like, hey, we were protected. If you do go through the probate process, it's actually required, but if you have a trust, it's not required. And so if person passed a few years ago, should you do it now? I would say if it's a few years since they passed, like there's nothing that's going to happen. But if it helps you sleep at night, then maybe it's $100 well spent. And all you do is you reach out to the legal news and they post it. It's probably $100. Last question. Is this recorded? If so, where do you find the replay? Yeah, so we try to record all of these and they are on our YouTube channel. So Castle Wealth Group, YouTube, just Google it and it should show up. So, yeah, there's a couple I missed because I actually forgot to hit the button to record it. But other than that, yeah, we try to record all these. And then we also like break them up into little snippets. So on our YouTube channel, if you haven't seen it, it has a wealth of information on a variety of different topics. So really helpful. So, all right. That is all I have. So with that, make it a great week. Take care. Go Pistons tomorrow. Bye-bye. Bye-bye. Bye-bye.